get into it. We'll jealously protect our new majority status, and that is by Ato Forson. And if you check out citynewsroom.com, we actually have an article about that. The minority leader in Parliament, Dr. Castle Ato Forson, has reaffirmed its caucus's determination to defend their parliamentary majority despite a Supreme Court ruling that temporarily halts a decision by the Speaker of Parliament, Albert Bagbin. And then the controversy arose after Speaker Bagbin on Thursday, October 17, declared 4 parliamentary seats vacant. This was due to 3 sitting members of Parliament, MPs, announcing their intention to contest in the 2024 general elections as independent candidates. Additionally, the second Deputy Speaker, Andrew Amwako Esiama, who originally entered Parliament as an independent candidate, stated his plan to contest the upcoming elections under the banner of the New Patriotic Party, that's the NPP. Bagbin's declaration would have shifted the balance of power in Parliament, granting the opposition National Democratic Congress, the NDC, Caucus a slight edge with 136 MPs compared to NPP's 135. The shift in number could have tipped the scales in favor of the NDC, making them the majority in the House. However, the Supreme Court, in a unanimous decision, ruled to stay the execution of Speaker Bagbin's declarations, thereby preventing the immediate vacancy of the seats and maintaining the current parliamentary numbers. Despite the ruling, Dr. Ato Forson, speaking at a press conference on Sunday, October 20, made it clear that the minority caucus is resolute in defending what they see as their rightful majority. He stated that his team would jealously guard their position and express their unwillingness to back down or relent in their pursuit of what they believe is a fair representation in Parliament. Yeah, you can actually check more on that on citynewsroom.com. All right. So what are your thoughts about this?
Well, very good morning once again to you, Chris.
Yeah.
My thoughts on Honourable Ato Forson's statement that they will jealously guard, that's the minority in Parliament, that they will jealously guard what they see as their right.
Yeah.
Now, you've got to look at the words, what they see as their right. You know, the custodian, or rather the power, law and order, and the ability to enact law and to uphold law and to amend law ultimately rests with the Constitution.
Right.
And who is the custodian of that Constitution? It's the Supreme Court.
Right.
The laws of any institution, as you know, including Parliament, are subservient to the Constitution. The Parliament Act, 1995.
Right.
Okay? So 1965. And then you have 1995. It all serves the Constitution. Parliament is the creation of the Constitution. And the custodian of the Constitution is the Supreme Court and the Supreme Court judges. Why am I giving you this preamble? Just to give you the background as to my submission. Now, what happened in 2020 with regards to Honourable Asiama, and when you had the Honourable Speaker then, Michael Quay Sr., declaring that the seat was vacant.
Right.
The law states this, that it's only the High Court that has the power to determine when a seat is vacant, ultimately. That is the law.
Yeah.
I'm not making it up. We can all go to Article 99(1), go through A, G, and H, go to Article 110 of the Constitution. As we're here, all viewers on ChannelOne are Googling. So what we're saying is based on fact, or what I'm submitting is based on fact.
Yeah.
It is the High Court that can declare that. The fact that somebody has done that erroneously, you cannot now use the foundation of an error in judgment. I'm talking Honourable Michael Quay Sr., the then Speaker, to say that's the precedent, let's follow it. The fact that somebody does 80 miles an hour and the speed limit is 65, you can't say, well, since he did 80, all of us can do 80 miles. So now I'm going to answer the question, or rather give my submission. Let the courts decide when a seat is vacant.
Right.
And that's my premise on that. But of course, there are valid arguments. Let us be fair to the conversation.
Right.
Somebody came on the ticket, and I'm talking an MP, on a particular party. And now they've decided to do what? Now change that allegiance, either to go independent, swap to another party, or come from independent to another party, as in the case with Honorable Asiama, as it is now. Given that that's the reality, and you want to somehow sanitize Parliament, that's why the framers of the Constitution put in the caveat that when you change, there are procedures to follow. But ultimately, the decision lies with the High Court. That did not happen in this case. Then the whole preamble, Chris, Honorable Harun Idrisu was the one who made a statement to the Speaker of the House, Honorable Abang Bagbin, that there has been a case meriting the vacation of these seats. He made a statement. A statement, per the Constitution, only allows for a review or an analysis of the issues contained in that statement. A motion, when you make a motion, that allows for that particular issue that you want to be reviewed to be voted upon. That's the key thing. To be voted upon within Parliament and then amended accordingly. Right. So the foundation is weak, and I say that respectfully. I want to be fair to the issue, Chris. But the foundation, had Honorable Idrisu approached the Speaker with a motion that these seats to be vacated, then the procedure follows through. Here's a motion, now we're going to vote upon it. We vote, and then the results of the vote are determined, and the outcome is then acted upon. But it was a statement. So I want to at least, I'm hoping when Victor comes, he can then, of course, engage me further. But I'm sure our viewers can do so accordingly. But that's the reality of the case. You issued a statement. The Right Honourable Speaker, Abang Bagbin, then proceeded, and to his credit, he said, let me check, or rather review.
Yeah, I remember he saying that.
Yeah, the statement here, and then come back to you with my offered opinion.
Yeah, which he did.
Which he did.
On Thursday. Yeah.
And then what he should have done, per the law, is refer it to the High Court.
Yeah.
And say, this is what Parliament has found. We want you to determine it, because the law states that. And it's interesting that the law, the framers of the Constitution, Chris, have framed it this way.
Yeah.
It means that Parliament cannot hold we, the people, to ransom. Due process you cannot be judge, jury, and execution. I'm talking Parliament.
Yeah.
There's a check and balance.
But, you know, because there's actually been a precedent with this same situation, I'm talking about the Famina MP's issue.
Yeah.
When that happened, when the Speaker affirmed in Parliament that his seat was vacant, why didn't anybody do anything about it? Because nothing was done about it. That's why I think he actually has come out to say, you know what, these other seats are vacant now. So I feel like if you really believe all these things we're saying right now, or if all these things stand, I feel like they should have acted at that point.
I agree with you 100%, Chris. You had 275 members of Parliament who were in the chamber at that time. But it's fair to remove one of those members, that Honorable Ayariga. He indeed questioned the Speaker as to the veracity of the statements of his opinion. So again, let's be fair to Honorable Ayariga that he questioned it. But the other 274 or so, we have to query, why didn't they do that?
Yeah.
But as I say, you cannot, because of a precedent erroneously given, use that precedent to carry on forward. Yeah. So that's, I think we have to challenge those members of Parliament. Yeah. Why didn't you say something?
Right. So how does this shift in these proceedings and, you know, with what's the judiciary is saying now impact governance and policy making?
Yeah. I mean, what it does now is for the Supreme Court to now come back to Parliament with its opinion, and its opinion, remember, remains supreme. I was listening to my good friend, Honorable Ayariga, on TV, mentioning that what should have happened is that it is the High Court that determines whether a seat is vacant. And the fact that the majority I'm underlining that word, the majority went to the Supreme Court is erroneous. How can it be? In any way, shape or form, the Supreme Court trumps the High Court. So it's interesting that Honorable Ayaraga even mentioned that why didn't the minority, the majority, I'm talking Honorable Afutu MP, Afenyo Markins. Why didn't he go to the High Court? There, no, Honorable Ayaraga has exposed the reality that he knows that the court, the High Court, do you get me? Right. The High Court is the one to declare whether a seat is vacant. Okay? But who supersedes the High Court? The Supreme Court. So whether you go to the High Court or it's, you know, 6 of one and half a dozen of the other. Right. The fact remains that we have a constitution that we all abide by, and when you do something that is in contravention of the Supreme Court's or the Constitution, you are held in check and balance, and that's where we are now. And so your question was, what do we do now moving forward? The Supreme Court will determine, and then Parliament will be properly shaped. This is not the first time that standing orders have been, how can I call it, amended or challenged, you know, to first as Attorney General. And there are many others whereby standing orders have been amended. I'm glad Victor is here. He can confirm what I'm saying. All right. It's not the first time. Parliament is not a unilateral body that tells us what to do. There is a supervisory body called the Supreme Court. All right. Okay. So joining us in the studio right now is Victor Kwajoga Adawudu, who's the member of the NDC Legal and Communication Team. Hello, sir. How are you?
I'm fine. Good morning.
Good morning.
And good morning to Ibrahim.
Good morning to you, Victor.
Yeah.
Right. I'm sure you heard a bit of what we're talking about. We're talking about the NDC Caucus making a great statement about protecting its new majority status. So what specific strategies would you say the NDC will be implementing to maintain this majority status?
First of all, let me wish belated happy birthday to one gentleman, Divine Jebele. He's called Igwe. And then the honorable member for Akan, Gomado, Engineer Gomado, belated happy birthday. I'm sure the constituents, they appreciate the work they are doing to lift people up and develop human resource. And that. First of all, I would say that all this that is happening within this country, our constitutional democracy, is pure politics.
Okay. Why would you say that?
Let me read. This is what the Supreme Court, on the occasion of, in the case of Waku versus Attorney General, Amwasiti, JSC, said, and I'll go and explain why what is happening is pure politics. He said this, in Waku and Attorney General, he was delivering, there was a time a Supreme Court judge who retired went to court and said that his benefits, looking at the law, what should be done. Then this is what, he read the judgment, the lead judgment. He said, after the overthrow of the Nkrumah regime, the judiciary came in for much criticism for the role it had played while the previous government was in power. It was said that it had departed from its traditional role as an independent arm of government and had become a willing tool of repression in the hands of the executive. It was also said that some of the appointments to the bench had been politically motivated, in that persons with known sympathies for the regime have been favored over those who exhibited an independent frame of mind. Worse still, it was said that some of the judges had become so depraved and demoralized that they habitually took bribes. The answer of the new administration was the wholesale dismissal of judges, cleaning the audience tables, as it were, and appointing new ones to take their place. But it was soon realized that merely changing personnel will not be enough. What was required was a reappraisal of the role of the judge in the body politic and the creation of the conditions necessary for the proper exercise of his function. What I'm saying is that judges and the courts playing into their hands or play into the body politic is not something new. It has always been with us.
Yeah.
Right? And what we saw happen from Parliament to what the Supreme Court have done is pure politics.
Okay.
You see, don't let, when the citizens were arguing that they did the wrong, the law was wrong, and look, they knew. That is why we always say the law is in the bosom of the judge. Look, I can tell you, that panel that sat down, I have appeared before almost all of them. I have been on other sides with some of even them in cases, and I know the depth that they have. Some even, some of them teaches civil procedure. So do not lose the fact or be hoodwinked to believe that when they were given this ruling, they did not know the procedure. They know it. And I'm saying that what they did was pure politics. Don't also forget that when the majority leader said that until the Supreme Court rules or say something, they are not going back to Parliament. And within the next day, Supreme Court has spoken. Okay, Supreme Court has spoken.
Okay.
You see eminent lawyers saying that, the Supreme Court has supervisory jurisdiction over Parliament. It is not true. You see, Article 2, only the checks and balances that you can check Parliament when they do any act or any omission or any law which they say that is inconsistent with the provisions of the Constitution. So the fact that you have checks and balances does not mean that you have a supervisory jurisdiction over them. And for me, what is happening, unless we have a political solution to this, this country will be plunged into constitutional crisis, because it's going to be a clash of egos. I'm an independent arm of the government, you are an independent arm of the government. So if the two, why do you want control? Right. You see, the reason why I think that this is going, and I said we need political solution to this, to have cool heads, to get into the backroom machinations that will have to be done for the two institutions not to collide.
Yeah.
Because if the two institutions collide,
that's chaos.
And it sparks, there will be chaos in this country. Because if you see the feeling and the anger within the people, because you see the mantra every time is go to court. Are you telling me that the court is a basic principle that whether the court makes a decision which is right or wrong, once it is there, you must obey, and you go back to the same court to correct or set aside that decision. I'm sure the Speaker's lawyer would do similar things.
All right.
But you see, the political angle of it is that, you see, we've been in this country where we know, the courts know very well that you cannot injunct a public institution when they are doing their duty. You see, and the processes that were filed, even the constitutional law student in first year will know that when it comes, the court is to interpret. But the process is filed ex parte. It means that no notice to the other side. And the court, in the same vein, the court said that the issue of natural justice is grave. And if the issue is grave, then they will take the action. So why didn't you put the Speaker on notice?
Okay, so
if it is natural justice.
Okay, you know what?
You see, so I don't want to go into where it is right or it was wrong. I'm saying that it has been politics, and people feel that it gets to a point that the court deliberately will not do the right thing and ask that, oh, come back to court and correct it. And people
All right.
are getting fed up with some of the decisions that come.
All right,
You
so
know,
you know what? Let's take a
yes.
quick break, right? And when we come back, you can continue, and then he will share his thought on everything you just. We are still looking at topics that are stirring up public discourse, and still on the matter of the parliamentary proceedings. You were saying something before we went on
Yes,
break.
so for the parliamentary proceeding, the NDC had become majority by operation of law. It is by operation of law. So that is what I believe with the sentiment within the party, the minority has said that they would jealously guard it. And I think that by operation of law, they are 135.
Yeah.
Until and unless the court or it has been served on Mr. Speaker and Mr. Speaker decides that he will abide by it, although it may not be right, he will abide by it. That decision lies with the Speaker.
Right.
And I'm sure tomorrow we would see, but by operation of law and their own statute, the standing orders, they have become the majority.
Right. But Ibrahim, let's put everything that's happening on the side. When you look at the numbers, who's the majority right now?
The majority right now?
When you look at the numbers,
It's the MPP.
why?
Because that's the reality on the
Because
ground,
what about those that have said, okay, you know what, we want to run independent? If they want to run independent, that means they're not representing any party right now.
No. Chris, if you pay your rent for 2 years in advance, that's 24 months, then after 22 months, you decide to live somewhere. Is your rent where you paid 2 years in advance expired?
But you're no more there.
No. You see, you can't say you're no more there because your term is not expired. But let me come to the issue of the law. You say that it is an operation of the law, and I agree with you. I agree with you, Victor. But when you go ultra-virus, outside of the law, then understand that you're not working within the confines of the said law. Article 99(1)(a) through to G and H tells you the law pertaining to how a seat can become vacated or vacated.
Yes.
What Honorable Bagbin did was ultra-virus. No, don't shake your head. It's the reality. Before you came, Chris asked a fantastic question. She said in 2020, when Honorable Michael Quay Sr. did the same thing that Bagbin has done, Honorable Bagbin, sorry, why didn't you lot, you as in Parliament, not just NDC,
Everyone.
Parliament for, why didn't you speak up? Honorable Ayariga did. He queried it. So since you didn't query the law when Honorable Michael Quay Sr. went ultra-virus outside of the law, don't tell me now you are operating the law. Parliament is the legislative branch of government. You have the power given to you by the Constitution, whose custodians are the Supreme Court judges, to enact laws, amend laws, etc. Now, you mentioned Article 2. The Supreme Court, Chris, the Supreme Court, their role is to interpret the law and apply the law. No, I beg you, don't shake your head. Let us be honest to the people.
The Supreme Court is to interpret, but once you have to apply the law, any court, any administrative, and anybody can apply the provisions. But once there is an ambiguity in the application, that is where they interpret.
But at this point, is there any ambiguity? No.
Chris,
there's actually no ambiguity when you look at it. But now why should they have come in if there's no ambiguity?
There's no ambiguity. What's the ambiguity? It's saying that in order to determine that a seat is vacant, go to the High Court, let it determine. Why is it that when we have a by-election and there's an issue as to whether the election was done correctly, you don't go to Parliament and say, Massa, who won the election? You go to the High Court.
Yes.
Thank you. And the Constitution, it's not, Constitution, I mean, Article 9, come on, Victor.
No,
I want to be civil here for the sake of our viewers.
No politics.
No politics.
Okay. No politics.
You can say politicization, because when you say, this is all politics, of course it's politics.
The Constitution itself is a product of politics.
So when you said that, I'm like...
It's the people who crafted, they were not lawyers who crafted the Constitution.
Maybe the nomenclature that you use, you could have said the politicization. What is this? Of course it's politics. Yeah. Politics.
We're all political animals at the end of the day.
The issue is this. The law says, come to me, High Court, to determine if a seat is vacant, so that you, Parliament, cannot be judge, jury, and executioner. In 2020, Michael Quay Sr., Honourable, became judge, jury, and executioner, and parliamentarians kept mute. They kept mute. That's to their discredit. Now, you cannot use that error to say that is the foundation. So you're not operating, as you say, to use your words, it's an operation of law. It is not. It is an operation outside of the law, because the 4 procedures per the law captured in Article 99(1), parenthesis A, tells you, through to G and H, tells you who can vacate or determine the vacation of a seat. And it is not Honourable Alban Bagbin, it is not Honourable Michael Quay Sr. So I beg you, go back, do the right thing. And it was also a statement, not a motion. I was telling Chris, Honourable Aruna Drisu, this whole preface upon which we've arrived here today was based on a statement.
Yes.
And a statement only allows for review, analysis. A motion properly brought to the Speaker then goes for vote, and then that vote is determined and the outcome is enacted. So the whole foundation,
let's just to explain the point. The 97 and 90.
So 1 minute. Yeah.
You see, the High Court has been given jurisdiction to determine whether you are validly elected or, as the dispute, that you have vacated post. Now, the person who applies the law to determine whether you vacated is the Speaker. He has applied that law. If you think that, right, that's where 99 comes in. If you think that I have not vacated my seat, right, that is when you go to High Court and say that I have not vacated my seat. And this is what is being said. That jurisdiction is what has been given. So it is the person who is affected, or
not the party.
Who invokes 99 and goes to the High Court and said that they've declared me that I vacated my seat.
I have not vacated. Yeah.
So that is when evidence will be taken to see whether really you have vacated or you have not vacated.
Okay.
I get it.
Where is it captured in the Constitution?
Oh, it is in there.
Oh, then read it for me.
From 97 is the application. And the difference between Michael Quay, Honourable Senior, and what Agban Bagbin has done is Michael Quay based his decision that the party has written to him that Honourable Isiema has vacated his seat. That's the 2 different things. That he based his decision that he has vacated his seat. In this scenario, it was a statement that was brought to court, and it was based on their own Article 93 and their own standing order. So once that statement was made, he gave opportunity to other sides to speak to the motion and speak to the statement that has been made. And now he has given information. So let's wait. For me, I am sure, and I'm saying that, let allow diplomacy, let allow the backroom work so that we can bring some sanity and understanding to this issue. If we allow egos to clash, from tomorrow, we will not, this country is the only country we have. But you see, nobody would also want to sit down and be taken advantage of.
Feel cheated.
Feel cheated. When you feel cheated, you know, reasoning is gone.
Yeah.
Right? When it comes to religion, politics, sometimes we don't reason. We don't reason. Rational reason is out. But let's allow cool heads to prevail in this matter.
Well,
I agree.
Well,
yes.
I like the fact that both of you actually agree that we should allow the cool heads, you know, prevail in this matter.
Allow the law to work.
Yeah.
Yeah, Chris.
You just had to throw,
allow the law to work.
You just had to throw that in, but then anyway, I mean, it all starts tomorrow, so all eyes will be on, you know, Parliament tomorrow, and we're going to definitely be showing it live here on Channel One TV.